you can hear me okay and see me, and I guess more importantly, Craig, who is the star of the show, or will be the star of the show in due course. This is the latest in the series of law school webinars I've hosted, and we've had a range of discussions on sort of my area of expertise in the past. I'm on extradition law and human rights and charity law and immigration law. And Craig, I asked Craig, and he kindly agreed to speak on his area of expertise, land law and property law in particular. Craig is Dr. Craig Anderson, a colleague of mine in the law school, has worked with us in RGU since 2006, and previous to that, had a practical and applied job in the law in the registers of Scotland as a researcher and legal advisor. And prior to that, I think was reading for his PhD. So welcome, Craig. Thank you. The subject for tonight's webinar is land ownership and land reform in Scotland. And Craig and I were just having a little chat before we started, and it's and I was saying, land reform is not thought to be the most sexy or land law, property law, sexy or interesting subjects, or maybe interesting is not wrong to say. It's certainly topical, but then once you scratch the surface, it's been really quite commonly in the news and an important and controversial subject. And we just came across an article in the P&J just yesterday on land ownership. About who owns Scotland, how that ownership is changing, and whether, I guess a more general question, whether that the current situation is inequitable and just the right one. So Craig will be alluding to some of these themes as we go along, and how it's going to work is I'm going to ask Craig some questions in and around land ownership and land reform in Scotland, and interject as appropriate as we go along. I think for 30 minutes or so, perhaps. We'll see how that goes. And then, as Heather said, welcome questions from you guys via the chat box after half an hour or so. So the first question is, I say, thank you, Craig. In the last couple of decades, of course, there's been a busy time in Scotland in law reform terms. Can you start us off tonight by telling about some of the changes that have taken place in land law in recent years, Craig?
Yes, of course. But just to start just by saying thank you for having me on, although I don't know that you're not setting expectations too high by calling me the star of the show. But yes, you're quite right. You're quite right that the last couple of decades has been really an unprecedented period of change, of reform in Scots land law. And it's since the Scottish Parliament was established in 1999, land reform has been relatively high on the agenda, both in the political agenda, both with the previous Labour Lib Dem coalition administration and the current SNP government. Now, a lot of this is not the kind of thing that's really going to attract most people's attention. The person on the street is not going to notice a more technical law reform, which may be very necessary, but it's not the kind of thing that grabs the headlines. There have been various, there's been a number of pieces of legislation on land laws, such as the Tenement Scotland Act reforming the law on ownership and management of tenement buildings, or the reforms to the land register contained in the land registration, etc. Scotland Act 2012, these are quite technical matters, but quite important, nonetheless not headline grabbing, not likely to affect most people's day-to-day lives. And even things like the abolition of feudal tenure, and the abolition of feudal tenure, etc., Scotland Act 2000, while it has a huge symbolic importance, is not going to have a great impact on most people's daily lives. But there are other reforms that have had greater practical effect, such as the right or introduction of a right of responsible access to land, and the so-called right to roam in the Land Reform Scotland Act 2003, and also various community rights to buy that we're going to be talking about a bit later on, are very significant in practical terms in changing the way the country runs.
Thank you. So there's been this change, and I guess you mentioned a critical date, 1999, and I wonder, I guess you're just alluding to the fact that all these changes were brought about by the reconvened Scottish Parliament on the 1st of July 1999, and were there these pent-up demands or policies in favor of change and they happened then after 1999? Will this pace of change, can it continue, or is it bound just to slow and settle in the future?
Well, I think it is. I think it's likely to continue. I mean, you talked about a pent-up demand for reform, and of course, perhaps once that has been addressed, once things that are on the long-term to-do list have been dealt with, perhaps there will be something of a slowing of the pace of change. But I don't think it's likely to change dramatically. I think there will be continued land reform in the future. The Scottish government has committed itself to future land reform, really to a reimagining of how land works in this country. And you see this in some more recent legislation, the Land Reform Scotland Act 2016, which requires, it does a couple of things. I mean, it does a number of things, but I just want to pick up on a couple of them just now. One is that the 2016 Act requires the Scottish Government to produce a land rights and responsibilities statement, which it has done. And without going into this in full, there's quite a substantial document going into this that you can find on the Scottish Government website. But it's very much based on principles of making land ownership accountable to communities, empowering communities. Really, it's captured, I think, the mindset of this, the whole approach, I think, is captured by the idea that you do see in this statement, that landowners, or people with rights in land, are to be seen as stewards of Scotland's land resource for future generations. So it's very much thinking in those terms. And on a more practical level, the 2016 also establishes a Scottish Land Commission, which is based in Inverness, which really its function is to conduct research and make proposals to make these principles a practical reality. And just a purely practical level, possibly slightly cynical, is if you set up a bureaucracy and ask it to make proposals, it will make proposals. So there will be further reform down the line.
Great, thank you, Craig. And I guess just one last maybe historical point, or I guess our whole discussion will be historical. But just from 20 years ago, there seemed to be, you alluded to these acts, a rush of technical law reform at the start. Amongst the initial acts of the Scottish Parliament in the early years of this century. Was that necessary? What spawned that early technical reform?
Right. I think a lot of it arises from the coming into existence of the reconvening of the Scottish Parliament in 1999. That before that date, in July 99, Scottish affairs had to compete for legislative time in the UK Parliament with with purely English affairs, and that meant that with the best will in the world, there was very limited time for it. And I mean, matters like the abolition of feudal tenure really was long overdue. It no longer, had not reflected actual conditions on the ground for a very long time. And really, that was a reform that was long overdue, and had Scotland had a parliament before 1999, would have happened earlier than that. And I mean, really, it's just, this comes back to this point about there being pent-up demand for reform.
And I guess then having the time in the Scottish Parliament dedicated, of course, solely to Scottish matters to enact those rules. I mean, what I'm kind of thinking is, I guess you said there wasn't the time or maybe the inclination of the UK-wide Parliament to amend the intricacies of Scottish land law, which then was possible after the reconvening of the Scottish Parliament in July 1999. But it brings to my mind the close relationship between sort of politics and political opinion and land reform. And I think that can bring us on to our next topic, which you alluded to in your introduction, was a community right to buy. This is, I guess, one of the major reforms that has happened since the Scottish Parliament began operating again. Can you tell us a bit about this and why this right to buy arose?
Yes, there has long been concern about the fact that Scotland does appear from comparative research to have an unusually high level of concentration of land ownership in quite a small number of pairs of hands, compared with other countries of a similar type. I mean, just to give a couple of statistics, according to research published in 2013 that was carried out for the House of Commons Scottish Affairs Committee, according to this research, there are 432 owners who own half of all privately owned land in Scotland. And another statistic from the same source is that 0.025% of the population owns 67% of all private land. Now, something so extreme cries out for explanation. Now, it could perhaps just be, well, this is the operation of a free market has led to this kind of concentration. But at the same time, even the most committed free market proponent would have to be concerned that this level of private land ownership often attracts state subsidy of various kinds, such as, well, hitherto EU subsidies, agricultural subsidies, often subsidies for related to renewable energy projects and so forth. There are various sources of public subsidy for this land ownership, and at the same time, many of these very wealthy individuals who own this land are benefiting from these subsidies. Often, many of them are paying little or no tax in the UK. Now, it is not fair just to say that, well, landowners bad or anything like that. Also, there is a lot of variation in how landowners conduct themselves, how they manage the land. Some are always going to be more interested, more able, more motivated than others. But there are concerns around this concentration of land, both from the point of view of the equality argument that it is toxic in society to have this kind of level of inequality between people. Often also the owners of these large estates will be absentee landlords who perhaps then you're just not then having the level of interest, level of motivation to play an active role in benefiting, in an active role in encouraging development of communities. And equally, there is the overmighty landowner, the overly interested landowner, the landowner who has such power over a community through land ownership that this landowner is a kind of monarch of the glen type, who is exercising, is in practical terms, is exercising powers that really should be under democratic control. Those would be the arguments at any rate. Those would be the arguments that those people who live on the land are better placed to see to its development.
Seem to be pretty good arguments to me. You make a convincing case. So the Scottish Parliament played heed to these arguments and introduced a community right to buy. Is that what happened?
Yes. Quite a fairly modest one initially. This was first introduced in the Land Reform Scotland Act 2003, and it's quite modest in scope. Originally, it was only aimed at rural communities for a start, and it's also this original right to buy is also restricted by the fact it's only a preemptive right to buy. So it can't force the sale of the lands. All the members of the community can do is register an interest in acquiring the land, and then if the landowner decides to sell, the members of the community can then attempt to buy it. But if the landowner never sells, then there's nothing they can do. There's nothing the community can do. It has been broadened out over time as well. In 2016, the restriction to rural communities was removed, so urban communities can now exercise this right to buy, but it is still quite a limited right, this original 2003 Act right to buy.
And that's is that the law that applies today? So the original scheme in 2003, or you mentioned some reform spread to urban communities in 2016? Is that still the situation today, or could there be what wouldn't be if it was not preemptive? Could there be a sort of compulsory purchase system? Could somebody force the sale of some land?
Yes. There have been further reforms. Two further community rights to buy have been introduced, one by the Community Empowerment Scotland Act 2015, and one in the Land Reform Scotland Act 2016. Those they work in quite a similar way to the original right to buy. So there are now three, and they work quite a similar way. They all involve similar steps. They involve a community body being set up, which is a corporate body, and then an application being made to the Scottish Government, which has to be satisfied that the application is appropriate. That's then registered in a public register called the Register of Community Interests in Land, which is free to search. You can find that online if you want to have a look at it. But where these two newer rights differ is that they can both compel the landowner to sell up, but they are more limited in their scope. The one that was introduced by the 2015 Act was concerned with abandoned, neglected, or detrimental land. So, brownfield sites, or say that land that has been allowed just to deteriorate and is not being productively used. In the 2016 Act, there was a right to buy to further sustainable development, which again can compel the landowner to sell. Although with that one, the community body has to have first attempted to buy from the landowner.
Okay, so it has grown somewhat, but still, a landowner, I say, save in those exceptional circumstances, is safe in his or her ownership. Is that accurate?
Yeah, but broadly speaking, that's absolutely right. These only apply in fairly limited circumstances. And there are a lot of steps to go through, a lot of hurdles to get over before the community can exercise these rights.
Mm-hmm. And so has these schemes been successful in meeting the goals set for them? I mean, I just saw on the news, was it a purchase in Dumfries and Galloway? Was it by a community, and it made the headlines relatively recently?
Yeah, there have been some quite high profile community buyouts, but it's difficult to know. I mean, it's certainly, for one thing, it's quite early to be able to say, especially with the two more recent rights to buy. There's just not been enough time for those to have had a real impact, particularly given how restricted they are. It does seem that there has been an increase in the amount of land that's been brought into community ownership. According to Scottish Government figures, just got them written down here, there 200 in 2000 and in December 2018 there were 209,810 hectares of land that were owned by 429 community groups, and 85% of that had been acquired since 2000. So it is presumably the case, and I think we can take it as a reasonable assumption that this is certainly connected to these rights to buy, but often this will the community buyout will happen without any use of the statutory processes. I mean, there is one community buyout that happened in the last few years at Gareth Alt in Sutherland, where it was the landowner actually who approached the community and said, well, do you want to buy this? And that's not going to come up in any figures that are going to be produced from the Register of Community Interests in Land or any kind of official source. But of course it happened. And so we would expect voluntary sales to be encouraged by the existence of the legislation. And of course there have been some sales under the legislation, but there are still formidable obstacles to any community wanting to exercise the right to buy. And one of these is finance. There are grants available from the Scottish Government's Land Fund, but these are hugely oversubscribed. And it's also an obstacle that you need to set up a community body and get local support in order to exercise the right to buy. Now, I'm not saying that shouldn't be the case, that you shouldn't have to go through those steps, but particularly with the preemptive right to buy, you're faced with two possibilities. Either you register speculatively, and you go through all this work of setting up your community body and getting approval and getting registered, and then the landowner never sells, or the landowner decides to sell but then changed his mind, which happened with one prospective community buyout at Loch Winnoch in Renfrewshire. That matters had reached quite an advanced stage when the landowner decided to withdraw the property from sale. Alternatively, you wait until the landowner decides to sell, and then you've got to rush on to get through all the necessary steps. And I mean, this was an issue with a community buyout in Portobello on the outskirts of Edinburgh. This was a church property that was being sold off by the Church of Scotland, and it was only because the Church of Scotland's initial attempts to sell fell through that the community body had time to get set up and get everything approved and get everything in place. So to come back to the original question, the right to buy has certainly changed the environment. It certainly created a different way of thinking about these things, but it's too early to tell how successful it can be, and there are obstacles to it being successful as well.
Yeah, I think, isn't it finance? Was it this recent story in Dumfries and Galloway? Was it the John Muir Trust contributed some finance? I think you get charitable organizations, or was that environmental organization contributing? And then I assume there must be excuse me, I'll probably get my terminology wrong, but some sort of deed, a community deed or something, where this land is held in perpetuity for the benefit of the community, and certain types of development cannot or can take place, and so forth.
Yeah. Well, it would be. I mean, the community body that you've got to set up is a corporate body, so it can hold the property. It will hold the land on behalf of the community, and it is regulated by the relevant legislation, which will control what it can do with that property. Absolutely. But yes, funding is always going to be an issue. I mean, you do have to pay the landowner the market value of the property, and that can be quite a substantial amount of money, quite difficult to raise.
Yeah, there's no getting around that, or the law doesn't provide for getting around that at all. You say there's these grants, but still, ultimately, it's a commercial transaction, and on commercial terms, and so communities may well just be sunk because they cannot raise in some cases perhaps millions of pounds to buy the land.
Yeah. I mean, if the legislation purported just to allow communities to seize control of assets without paying market value, then there would be fairly obvious human rights concerns about that. Even large landowners benefit from the property protection of Article 1 of Protocol 1 to the European Convention on Human Rights.
The right to property, yes, indeed.
Yes.
I guess there has to be that commercial element to it, I suppose, doesn't there? So I guess all of this, we're coming just about coming to an end shortly. But I guess one of our final questions is: have all of these changes that have taken place over the last 20-odd years change the outlook towards land ownership or understanding of it? I mean, remember, and I first moved to Scotland, and I thought, there's no criminal trespass in Scotland. It's somehow very symbolic that Scots have a right to go anywhere in Scotland unless there's some interdict preventing them from doing so. And correct me if I'm wrong on that score. But there seemed to be more a sense of Scots owning, having a stake in their own country, even if they didn't own it technically. Has this helped in that regard? Am I accurate in this sentiment or not?
Yeah, I think that would be fair. I mean, I think there is a traditional view of ownership that has the owner of property as the absolute master or mistress of that property. I mean, if you look at the institutional writers of Scots law, you will see statements like this, that land, the owner of property has absolute right over that property as long as the use of the land, the use of that property doesn't infringe anyone else's rights. And that the owner of land then is not answerable to anyone for what he or she does with that land. And I think we have certainly moved from that idea. I mean, this idea that you see of, I mentioned this already, this idea of landowners, as said in the Land Rights and Responsibilities Statement of the Scottish Government, this idea of owners as custodians of the land. They are custodians of the land for future generations, and the community on the land should have a greater say in the management of that land. That, as you say, this idea of the people of the country as a whole having rights of access to the land I've mentioned already. I think there is this shift away from ownership of land being seen as this absolute right to do whatever you like, as long as you don't affect anyone else, to being something much more qualified. I think that is a fair thing to say.
And that's, well, I think to my mind, a positive development for all of Scots that move has taken place. So we find ourselves where we are now after 20 years in the last government, who now has a majority with the Green and the coalition. So an ability to enact law more readily. Does it perceive, or do you perceive, maybe more to the point, a need for further reform? Are we now in a position where you could say the land ownership and these community buyout rules are sufficient, or are there issues crying out for further reform?
Well, I mean, fundamentally, the question of whether there should be further reform is a political one, and it's not. I mean, although there is a fair amount of cross-party support in the Scottish Parliament for these. For this approach, the change in approach. It's far from uncontested. There are arguments on the other side. For example, there might be an argument that if you have too strong a right for communities to take ownership of land, that might disincentivize investment in land. If you're going to spend money in developing land and then have it taken from you, well, that might discourage investment. But if the goals identified in the Land Rights and Responsibilities Statement are to be achieved, it's hard to see how further reform can be avoided. And one thing that has been mentioned, for example, there is the role of succession, the law of succession in keeping these estates intact. Generally speaking, the law of succession has allowed large estates to be kept intact and has not tried to break them up. And it's possible there will be developments in that area in the future. I think probably the area that it's easiest to justify and hardest to see a case against increased rights to acquire land is in the area of derelict land. But one thing I think perhaps could be paid attention to is having perhaps a bit more of a coherent vision of how this works. I mean, one thing that strikes me is that often a lot can be achieved without state intervention. Now, there are lots of things only the state can do, or only the state is likely to do. But equally, a lot can be achieved through private means. Now, in just to think about more traditional property law ideas, it is the case that through the doctrine of positive prescription, if I can get my name into the register against a particular area of land and I possess it unchallenged for 10 years, that becomes mine. but it's like oddity if we are interested in bringing private land, bring derelict land back into productive use, is that in the reforms to the land register in the Land Registration Act 2012, that possibility was largely removed. So that then leaves us with this very cumbersome, very bureaucratic process where you've got to get enough people together to get a community body set up. You've then got to get, you've got to satisfy the Scottish Government that you've got a good case here. You've then got to ballot the community to show you've got support. And so there's so many points at which this can fall. And therefore so many points at which you can end up on a path where this land just ends up staying derelict. And this is perhaps something, not necessarily a different approach, but a broader set of approaches is perhaps called for in this to deal with this problem.
That's a very fascinating example. If I could just maybe one question that it just came to my mind, and then we can pass over to our audience for further questions. I hope you don't mind, Craig. You mentioned succession, and my and they're obviously, are these big landholdings held in trust or something? Because in other countries, it's just the law of succession, right? That the landowner dies, and either it has to be split up to the male heirs, or inheritance tax is so burdensome, some will have to be sold to pay 40% inheritance tax. Why has not the law of succession or inheritance tax broken up these big estates?
Well, I mean, sometimes it will have done. Of course, if there's a large tax bill that can't be paid without paying, without breaking up the land, selling it off, that no doubt has happened sometimes. I mean, it has happened sometimes. But this raises wider problems of tax avoidance schemes that, and of course this is something that the Scottish Parliament has very limited ability to deal with, because tax is largely a reserved matter. So it would be necessary to have the Westminster government. The Westminster government involved in that, and have them sympathetic to these goals. But yeah, and quite often land will be held in trust, or it'll be a private company which holds the land. I mean, you were talking about some community buyouts that have happened. Quite a major landowner in, well, it's quite often said that the Duke of Buccleuch is a major landowner in the south of Scotland, but in fact, the Duke of Buccleuch owns nothing. What the land is owned by is Buccleuch Estates Limited, which is a private company behind which the Duke and his family stand, and this is in the current law. This is a legitimate thing to do. It does limit the possibility of any kind of succession regime breaking up large estates.
Great, thank you very much. I was just sorry, that was just a question that sprung to my mind.